Greetings, everyone. My name is Angela Acheng, and I'm the moderator for today. I'm a lawyer by profession, and I'm a trainee advocate at Kenya School of Law. I'm also the founder of Sharia Clinic. So before I bring the presenter of today, I would like to talk about Sharia Clinic. So Sharia Clinic is an online or virtual Kenyan-based legal aid firm whose primary objectives are two. Number one, we seek to provide legal aid services to Kenyans who can't afford it, that is pro bono services. And number two, we seek to enhance the participation of young lawyers and advocates through equipping them with advocacy skills. So that's what we do. And so far, we normally have our meetings every Saturday, 8 p.m. to 9 p.m. So far, we have various topics and various presenters who have presented before us. Number one, we've talked about public participation with regards to government projects. We also had a topic on data protection and data privacy. We also looked at constitutional amendments and the BBI. Number four, we looked at copyrights and with relation to the music and movies industry in Kenya. We've also looked at mental health and the laws pertaining to mental health. We've also looked at mob justice. We also brought Advocate Ruth Tanui, who talked about conveyancing and the whole legal process of conveyancing, how to buy property in Kenya, how to sell property in Kenya. We also had Counsel Lewis talking about judicial restraint and judicial independence. And we had one of us present on defamation. Recently, we had another presenter who talked about this current legal affairs on Afghanistan and the US, and it was titled The State of a Collapsed State. And we also had Counsel Cloud Kandem talk about succession, intestate succession, tested succession, what normally happens when someone dies without a will or when someone dies having written a will. And finally, last week, we looked at Counsel Hassan talked on the jurisprudential question on whether judges make the law or declare the law. So today, we are going to also have such a session. And maybe I can now introduce the presenter of today. So he's known as Counsel Osumba Collins. So he's a human rights and constitutional lawyer. He's an advocate trainee, meaning he's at the Kenya School of Law undertaking his advocate training program. He's a writer with People Accolades Law Magazine, Palm. And he's a political commentator, and he went to Kisii University. So, yeah, so Counsel Collins Osumba, you're most welcome. You will take around 20 to 30 minutes to present on today's topic, and today's topic is very interesting. It concerns the Sexual Offences Act and the dilemma of mutual adolescent sex in Kenya. We all know that even leave alone morality and the law, we all know that teenage sex is happening, so we can't bury our heads. So that's why we are here to listen to counsel present on this issue, and then we can ask him questions concerning this teenage sex and the boy child being convicted for defilement, yet both parties consented to the sex. So it's going to be an interesting discussion. So asante sana for coming on board. And counsel, now you have 20 minutes. You may now proceed. Thank you.
Right. Thank you for that wonderful introduction. And I also want to, most sincerely congratulate you for this project. I think it's wonderful. And maybe just to request those who are here that we need to talk to people so that they be attending these sessions. This is an opportunity for a person to learn about the law for free. It's not easy. If you go to an advocate's chamber to even seek an opinion on the most simple stuff, you'll probably be charged. So I will not want to waste a lot of time. I just want to hit the ground running so that we have a discussion. I know that my colleagues are here. I can see them, but maybe just to, do a disclaimer that so that we stick to the objectives of Sharia Clinic, that we take out legal message out there, This session is not going to be, your typical conversation, among lawyers, because then it will lose the meaning. It's not going to be full of sections, and judicial precedents and all these other issues. We just want to have a discussion for the benefit of those who might not have knowledge about the law. So my topic, as you have been rightly told, is on the Sexual Offences Act, the dilemma of consensual or mutual adolescent sex in Kenya. And this is a very controversial topic. We may even be tempted to say that it's political. But for those of us who are in the legal circles, we are always told that you must learn to divorce. You must learn to divorce your emotions or your morals with the law, right? So that you're able to be objective. So just to get into what I prepared, I want to just do a little introduction so that we understand where we are coming from, right? How did we get here? And before the enactment of the Sexual Offences Act in the year 2006, the laws pertaining to, or the laws, basically pertaining to sexual offences in Kenya were very fragmented, right? So you had provisions of the Penal Code, provisions of the Criminal Procedure Code, and even the Law of Evidence Act that were providing for the manner in which sex offenders were to be treated. And at the time, during that time, the Kenyan society generally, was very skeptical of rape allegations, that were being made by women. And I think that is because in the absence of a law, it was very difficult really to prove these allegations, because sexual offenses in their very nature are very easy to allege. I mean, any other person out there can allege that, he has been raped, she has been raped, she has been defiled. But the real issue is in proving, that they said or the alleged offense really occurred. So in 2006 then, and because, there was a rise and an increase in sexual offenses in this country, the legislature in its wisdom, found it necessary then to amalgamate all those provisions and come up with a single law that then provides for the manner in which sex offenders are to be dealt with. And that is what led to the enactment of the Sexual Offences Act, which I will call the SOA so that we can save a few seconds. So the SOA was enacted in 2006, and its primary objective was basically to respond to the increase in number of sex offenders. But you see, at its enactment, it was a good law. I still think it is a good law. In fact, Professor Brett Shadle of the Department of History at the Virginia State University described it in 2006 as the most significant milestone in the history of sexual offenses and in the history of laws in Kenya. I share those sentiments. The SOA was a very brilliant piece of legislation. It still is. And if you want to appreciate this, you just need to have a 5 minutes conversation, with somebody who has been raped. It is something that really changes your life changes your life, the whole of it, for a lifetime. You may never be able to really recover. So what then is the issue? Why do we even need to have this conversation in the first place? This conversation is very germane because we are living in a very fast-paced society, and the dynamics around sexual offenses have really changed, right? Today, we have a young population, and when I talk about a young population, I'm not talking about people who are 19 years onwards. I'm talking of those who are those who are 18 years of age and below. We have a young population that is way too exposed, that the one that we had in 2006 when we were enacting this piece of legislation. And if you want to know this, you just need to have a conversation, with a child who's 10 years old, right? They will be able to tell you about politics. They'll tell you about football. They'll tell you about, social issues. right? And I'm reminded, recently there was this popular, genre of music called Kenge. I don't know if it's still there because I don't listen. Kids, you would walk around the streets, you could walk around the streets and find very young children, singing those songs, word for word. And then that just tells you how exposed to society we are currently, right? So then there is need for us to tailor make the Sexual Offences Act, and in particular, Section 8.1 and Section 11.1 of the Sexual Offences Act to be able to respond to our current societal needs, because law exists to serve the society. The society does not exist to serve the law. My feeling is that if we continue to have Section 8.1 and Section 11.1 of the Law of Succession Act, of the Sexual Offences Act as it is today, then we might end up criminalizing an entire generation, right? So then we want to look at the definitions, right? Because we are talking about consensual adolescent sex. So it is important for us to understand who then is an adolescent. Adolescence is also known as puberty. It starts from the age of around 10 to 18 or to 21 for those who experience adolescence in later stages of life. But then this discussion really is restricted to the ages between 13 to 18 or thereabout, right? So someone who is at the age of 13 years or up to around 17 years and several months would be considered to be an adolescent, right? And an adolescent in our Kenyan context, in our legal context, is a minor, all right? So who is a minor? A minor legally is any person who is below 18 years of age. That definition is contained in Article 260 of the Constitution, contained in Section 2 of the Age of Majority Act, and also Section 4 of the Children Act. If you find time, you might look at those provisions in your own time. So that is who a minor is. So adolescents are minors, right? They deserve equal protection of the law. We want to look at our statistics, having understood who a minor is, right? Because if you're having a conversation around legal reforms, then we also want to back our legal arguments, and this is a scientific matter, so to speak. So we want to, back our legal reasoning or our legal argument with some science or with some figures. The Kenya National Bureau of Statistics, did a study, I think in 2017 or thereabouts. The study was called Kenya Demographics and Health Survey, right? KDHS. That study revealed that about 15% of women and 22% of men between the age of 20 and 49 had their first sexual intercourse at the age of 15. Let that sink in. There is a very significant number. The same study also showed that about 46.5% of girls and about 50% of boys had had their first sexual encounter before reaching 18 years of age. Those are staggering numbers. We can't just now pretend that children are children and that they're innocent. The truth of the matter is these kids probably know more about sex than even us, who are adults. Those are our statistics. For us to have a society that is able to function, we need to have laws that reflect the reality of the society. Today, as a country, we cannot sort out our issues by applying, the laws that we inherited